AJ, are we good to kick off?
We're good to go. We're good to go. Good, Vixen. Thank you.
Thank you so much. Good afternoon to all our delegates in this afternoon session. Today, as you know, the SA Bar Association hosts a speaker on a weekly basis to deal with a legal topic intended to assist our practitioners or any other people that are interested, both locally and internationally, with training and development. And the purpose is there to feed the core values that the SA Bar Association holds as an organization. This week, we have the privilege of our colleague, Advocate Ahmed Cajee, that joins us. And thank you so much, Ahmed, for your precious time. So to introduce Ahmed, he's got over 20 years experience as a member of the Johannesburg Bar. He's with the Johannesburg Society of Advocates, and relevant, especially relevant for today, he's also a member of the High Court Committee at the Johannesburg Bar, and he has been so for some time. The function of this committee, this High Court Committee, is to liaise with both the JP and the DJP on the smooth running of the High Court, together with other stakeholders. The DJP recently asked the committee for their views and recommendations about the reopening of our courts and the continued use of the virtual platforms after that. The discussion this afternoon is going to be more in the form of a debate which myself and Ahmed will facilitate. Ahmed will do a short introduction, and then after that we're going to open the floor for input, questions, comments, to give ourselves a better feel of what the energy on the ground is around the topic. May I ask that for the duration of the afternoon program, that you keep your microphones and camera off, and when you want to make a contribution, please raise your hand, and either Cajee or myself will then call on you. And when you address the floor, please turn your microphone and your camera on for the duration of your contribution. At this point, Cajee, could I hand over to you?
Thank you, Ronel. Okay, yeah, guys, basically this is just going to be an informal session. As I've said, I mean, I'm not here to talk to you about anything. It's more for us to gather views. As explained by Ronel, I mean, we were recently asked as one of the stakeholders about our views and recommendations about the reopening of courts and the continued use of the virtual platforms after that happens. Now, I just want to put you perhaps a bit in the loop. As you recall, even before COVID hit, we were already going towards some sort of virtual platform and digitalization with the introduction of case lines. And then there is another there is another element to this court. I think it's called Court Online, which was going to make it even more extensive than initially envisaged. So so just keep that in mind. Now, as she's explained, you know, over the years we've been part of one of the stakeholders who regularly interacts with the JP and the DJP about the smooth and efficient running of the courts, along with organizations like the Johannesburg Attorneys Association, but also all the other stakeholders. I mean, I'm talking of a state attorney, legal aid board, National Prosecuting Authority, Correctional Services, Department of Public Works, even though they don't always participate, the court manager, the office of the Chief Justice. So we all get together every 3 months, and then we discuss all the different issues that that affect the smooth running of our courts. And in our interactions with the JP, we also have other stakeholders like the different magistrates from all over Gauteng, and as well as representatives of the High Court in Pretoria as well. That's a much bigger meeting. But for present purposes, we're talking about the Johannesburg High Court and our interactions with DJP Roland Sutherland. So guys, I mean, basically, so that's basically where we at now. As you guys know, we've had this COVID, and COVID, I mean, brought in a radical, what is the word, change in the way we practice law. Courts, I mean, open courts virtually closed down for quite a while, and for the most part, they have remained like that. The only courts that are running, I know, in the High Court are the criminal courts, and now and then, and I think the urgent court. Other than that, I think most courts have been run virtually, and that includes the civil trial courts. And so that has been the situation we faced with. But now it seems as though we're entering another phase as far as COVID goes. It's no longer considered a pandemic. Now they're calling it an endemic, and we need to try and return to normal ASAP. But in anticipation of to get back to the DJP about these issues he's raised about coming back to normal, I mean, I asked a few questions on 1 or 2 WhatsApp groups that I'm a member of, and the response was overwhelming. I mean, as to how we should get back to normal. Generally, the feeling is that as far as trials go, we should try and get back to normal courts. But as far as motions go, I mean, the opinion has been widespread across the board. And strangely, and I say this guardedly, is that it seems as though our junior members who were most affected by this lockdown. A lot of them, not all, but quite a substantial number of them, especially our junior baby members, seem to prefer the online system, whereas in discussions with the DJP, it would appear that they were the worst affected by this lockdown and the fact that courts are no longer open court. One of the main reasons for people who say we should continue with virtual court as far as motions go is the security concerns in and around the High Court. Now that's a debate and topic all by itself. I mean, we can spend another whole session just on how to go about improving that. But one thing I must tell you is that magistrates' court, for the most part, have been functioning normally. I mean, of course, with protocols involved, and that includes a regional court, which is now not too far from the High Court itself. So yeah, I mean, that's where we are at. I mean, so we're just going to be facilitating a discussion today. We're not going to be, I mean, I'm not here to tell you my views. I do have some views, but I mean, it's not for me to try and convince anyone about it. What I'm saying is right. I'm just, basically just trying, it's just a fact gathering exercise to see what 2 other members think of the legal profession thing, to say, should we go back, and if so, how? There will have to be a return to some sort of normality. I don't think it's a question of if, but how and to what extent. And to what extent do we still continue using the Teams platform? I was actually surprised. I mean, I would have thought that more people would have said that, you know, as far as opposed motions go, people would prefer the virtual platform. Unopposed should be back to open court, but it's actually not that. It seems as though quite a sizable number of people are saying that opposed matters should be in open court and maybe unopposed matters shouldn't. But anyway, that's one of the anomalies of the responses we've received so far. So okay, I think that's so that's where we are at. I mean, and then I'm gonna open it up to your floor and just try and get your views as to what you think should be the way forward.
Thank you, Ahmed, for the introduction. Perhaps it will be a good idea to get a feel from our attending delegates. You will see on your screen, and I just came up with it, so it's not a formal survey. On your screen, you can raise your hand, and perhaps let's ask this question to get a better understanding. Those delegates present, unqualified, do you think we should go back to normal physical court? And if you do, then perhaps you can just raise your hand on the facility which is available. If you click on the 3 dots, you'll see there is an option to raise your hands. And then I'll ask you to put your hands down after that. So where you see the little camera, the microphone, the share screen with the arrow, next to that, click on the 3 dots and then activate your hands up. And let's scroll. You can then also yourself see, if you scroll through the attendees, you can see whose hands are raised and whose hands are not. And from looking at that,
Ronel, just give us an indication what the other questions will be as well.
well, we'll get to that. So the first one is
so that we just know what we're voting for.
No, we're not voting on anything. We're just doing a survey. So the question now is, do you think we should go back to physical court? If your answer is yes, then raise your hand.
Ronel, I think it's more complicated than that, because it's, in my opinion, it should be half and half, but there's no question for half and half.
Yeah.
So I'm sure I'm saying now, so yes or no.
We'll get to that. The outright yes guys, those are the guys that should raise their hands. Okay, and I'm seeing about 4 or 5. There's more, 6. I see 6. Okay, those are our outright yeses. You can then drop your hands if that's okay. And then one more, okay. Njabulo, if you can drop your hand, I'm going to ask the next question. I'm just making notes as I go along. So there's 6 or 7 out of the 30 on an outright yes. And then the outright Njabulo, can you drop your hand, please? Thank you. Okay, and then the outright no's. Can you raise your hands? If there are any outright no's, we should not go back. We should not go back to physical court. I'm counting 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. So that's about 11 on the outright no's. All right, let's take the floor then to the outright yes. You can take your hands down if that's okay. Thank you very much. The outright yeses. Can we hear the motivation behind that? What would just raise your hand if you have a contribution on the issue of your opinion, yes, we should go back to the traditional physical court. Is there anybody that'd like to motivate their reply? You can just raise your hand. And Ahmed, Yasat, can I hand over to you? Please turn on your microphone and your video and let's hear it.
Perfectly in order. Thank you so much, Advocate Ferguson. I'm going to motivate for yes in a manner by a simple suggestion that court by the whole virtue of the theatrics in court is essential. Body language in court is essential. There's a lot of things that you read to reading a person is essential, and all of that is unfortunately lost on the through the virtual platform. That ends my submission.
All right. Any other outright yeses? Okay, let's go to the no's. Can you raise your hand? Let's hear why your outright no. Romeo, yes, good to see you. Please turn on your camera and your microphone.
Thank you so much for this opportunity, Ronel. I'm one of the beneficiaries of virtual court and how virtual a platform actually work. At first, I was not actually much more willing to be a participant of virtual things, but using case line as well, and also seeing the benefits and the convenience of using virtual court. I'm not for actually going back, because I think when you take 10 steps forward, you don't need to take 10 steps back to actually regress. I think for me, COVID has taught us a lot of convenience and how we can actually function without being within a physical court. And then I think for me, that is the benefit and that is the future, and it can actually work. And I believe that it is actually the future, and we must actually embrace it and actually use it for our benefit. Because I'll give you, for example, Ronald, if I have a matter and I'm in Cape Town and I still want to appear, I can do it in a virtual court. But if I'm not in the province, then it means that I have to hand over the brief from to someone else. A person who could not be briefed in Polokwane, was doing matters that are in the Pretoria High Court because of virtual court platforms. So for me, the benefits are too many, and I believe that it should stay that way. Thank you so much, Ronel.
Thank you so much.
Thank you once again for facilitating the program, and you are looking good as usual. Thank you so much.
Romeo. Thank you very much, Romeo. The one concern, Ahmed, if I may, the one concern that was raised in favor of going back to the virtual court was, the physical court was the juniors who did not have the access to what we had when we started out. I think Romeo's just raised an interesting one, that in fact it has made our courts more accessible because the virtual platform is geographically unlimited. Excellent point, Romeo. Thank you so much. Catherine, let's hear what you say. Your camera and microphone, yes, please.
Hi, Ronel. Sorry, I won't turn my camera on. I'm a member of the Johannesburg Bar. I understand that for juniors, you learn a lot if you're in an open courtroom and you're watching your seniors moving matters and so forth. But as an advocate, the time wasting in court and also the safety aspects of attending the High Court and now having to attend the High Court with a laptop and expensive equipment. First of all, the time wasting, you can do so much more in your day. And what we do is we bill time. So you can be far more productive working off the case lines or case lines in the Teams platform. And secondly, I mean, until the security aspects in the High Court in Johannesburg are resolved, and we don't know when that's going to happen. It hasn't happened. It's got worse during my 10, 12 years at the bar. That's a hazard that puts all of us at risk, having to attend court on a daily basis or weekly. Thank you.
Thank you so much. Absolutely. I think the one pandemic has been perpetuated by an old problem, which is the security at the logistical challenges of security. HB, let's hear what you say. I'm quite curious to hear.
Can you see me?
No.
Oh, sorry. Maybe if you press the button with better, you might. There are really three things that I want to say. The first is that the question is, where are we going to be in 2040? And the answer is not in a physical court. That's not where we're going. The sooner we get out of it, the better, because if we're going to be there in 2040, we may as well be there in 2030, and we may as well be there in 2022. And as far as whatever the teething problems might be, we must sort those out and go for it. That's the one thing. The other is this whole question about demeanor. So the whole idea is you want to have a physical trial because demeanor is important. You have to see the witness, and the only way in which you can determine whether the witness is lying or not is to have regard to demeanor. That's absolute nonsense as far as I'm concerned. I thought actually two things about it. The one is, in all the years that I've been at the bar, I've never been in a judgment, never seen a judgment where a court says, well, I think this, and I'm not sure what to do here, but I think Jimmy was lying. His demeanor was whatever. He was shifty and he was uncomfortable, and therefore I reject his evidence. I've never actually seen it happen. The second is, I don't even know that I trust a judge to determine demeanor and whether someone is lying. I've been an arbitrator, and I've never had the guts to say, well, I think this person is lying because of the way he's testifying. So because of that, I actually did a quick search of SAFLI to see how often references are made to demeanor. And what I found virtually immediately is a judgment given by Judge Piet Meyer, reported in the end of last year. It is Standard Bank versus Sebanda, 2021 5 SA 276. It's an excellent judgment, and he deals with how demeanor counts for nothing. He quotes a number of judgments where the courts have said, be careful, but more importantly, he refers to two articles that have been written by some expert, Garbett or something, the chap's name is, where he says judges are no good at lie detecting. In fact, it's more likely that they'll think that an honest witness is lying than the other way around. And I think the whole idea of this thing about demeanor and why it's important to have trials for that reason, there's no basis for that. In fact, I don't even think that it matters if the judge doesn't even see the witness. I mean, the witness could even testify with a video off and it wouldn't make a difference. In fact, what Meyer says is, if you read a judgment, then already that's not a judgment. If you read the evidence, if you never even saw the witnesses, you can make findings in respect of who you want to believe and who you don't. And in fact, judges do that on appeal the whole time. The third thing that I want to say is that whatever we think we're going to do in the High Court, there's still what's happening in arbitrations. And there's a reason why arbitrations have become more and more popular. The one is because you can choose your judge. The second is you don't have to go through all these hoops about having 5 or 6 pre-trial conferences, and every time someone delivers a document, then you have to have a pre-trial again. You don't have this problem that if the matter is postponed, you have to wait another year. And more importantly, you can actually have your arbitration without doing it physically. So I'm involved in arbitrations at the moment where Fritz Brandt is the arbitrator, and he sits in Stellenbosch. We are here. The witness could be in Timbuktu for that matter. And no one has to go anywhere. No one has to sleep over. No one has to live in a hotel for 3 weeks. And as Romeo said, it is quite possible for us to appear in any court at any time. But it's a no-brainer. There simply is no basis why we should go back. And maybe there's actually a fourth point, and that is, I'm pretty sure that in the past 2 years, whilst we had COVID, the Department of Public Works probably has spruced up the court completely. They've retiled everything, they've repainted everything, they've redone the toilets. In fact, I'm sure they did none of that. So, I'm sure that's not a place we want to go back to. I'll be surprised if any judges want to go back to that. I'm sure that, they find it as convenient as we do. It is possible that they want to go back to court so that they can walk in and everyone can get up and bow and carry on. I was acting as a judge last year in August, and I missed that. But that's not a basis to do any of this. Sorry, I spoke longer than I intended to.
No, thank you. Thank you.
Sorry, before we take any more questions, HP, you actually quite, and even Romeo, your guys, actually, it's quite interesting because I thought that there was general consensus that trials at least should go back to normal. But anyway, it's interesting what you guys are saying. It seems as though there's not even consensus on trials or civil trials themselves. Thanks about that.
And then I see Mohammed, I see your hand is raised. Mohammed Patel, colleagues, would you mind turning your camera and your microphone on for us while you share your views?
Thank you so much, Ronel and Ahmed Cajee. I'm trying to switch on my video. For some odd reason, it's not working, so I guess just my voice would do. I concur with both Romeo and HB Murray. I think from a junior's perspective, just to give you a bit of background, this is my second year of practice, and I think it would be good just to voice my opinion because Ahmed Cajee did state that juniors are one of the hardest hit in due to the virtual hearings. And I can just speak from my perspective because I'm virtually in court Monday to Friday on the unopposed role. So that's where I'm coming from. I totally agree with virtual hearings. It saves me as a baby junior, it saves me time, it saves me money, and everything is paperless. So in terms of the environment and cost to me as a baby junior, it is working effectively and efficiently. With regards to an issue that I've been picking up now since this pandemic has turned into an endemic, is that certain judges, I think it was the acting judge Mlambo and Sutherland, that has now given the discretion to certain judges to have matters heard either at their discretion, either in open court or online. And the issues I'm facing now is if I get 4 or 5 matters a day, and it's between different judges, and some judges are having it in open court, some judges are having it online. I'm sitting there in court whilst I'm busy on my phone, and there's no infrastructure surrounding me to enable me to be both in court and online at the same time. So there needs to be uniformity if the move is to actually go back. Because, I mean, for example, in Pretoria or Joburg, if you look at any of the courtrooms, there's only 1 or 2 plug points for 40 or 50 practitioners. There's no Wi-Fi. The signal in Pretoria and Johannesburg, depending on where you are, it's virtually none. So if there is a move to go back to court and we're going to still use case lines, how is that possible for a junior? Because now I have to go and I have to bring my laptop, I have to get data, I have to go through the riffraff of town and actually enter the court building. And I mean, that is a huge, that puts us juniors into a worse off position. And then lastly, with regards to work as baby juniors, you know, it's very difficult at the moment to get work. And if we get, for example, 1,000 Rand to go and note a judgment or 1,000 Rand to go and move an unopposed matter, it's costing me $400 to $500 just to get to court. And then, then at the end of the month, I have to pay my fees and my chamber fees, which I mean, it's unrealistic for a baby junior to do. Thank you. Those are my submissions.
Okay, can I just be a bit provocative now? To all the people who are saying yes, and especially the juniors, and this was something that was raised with me recently by my committee head, Advocate Rome SC. What if the court, by some fluke, you could relocate it to Sandton Square, if you could put it there? Would these concerns still be relevant, or is it just the location of the court that is causing a lot of problems?
No, it's not the location. Sorry, yeah. It's nothing to do with the location. In fact, you know, and something that I find funny is that some of my colleagues, when they have a matter, they get into their car and go to chambers in Sandton to go to do the matter virtually. I mean, why don't you do it from home? But,
no, I understand that, but I'm just addressing the safety concern raised by Mohammed specifically.
Yeah, but you may remember that
because quite a lot of these safety concerns have been raised. So I'm just asking specifically for those who are concerned about the safety aspect.
Yes, well, I don't think it makes a difference.
Okay.
Yes. Thank you, Marilyn. Let's hear you. There we go.
Good afternoon, Advocate Ronel, Advocate Cajee.
Marilyn, I've got problems hearing you.
Hear me, Advocate Ronel?
Okay, Marilyn, I'm going to come back to you in a moment. Let's just check data. I don't know, Ahmed, are you also struggling to hear Marilyn?
Yes, I'm also struggling.
We're going to get back to you.
I just want to say now, isn't that technology one of the challenges? What if technology breaks down and you're not able to be more physically? I mean, you understand that's also something we need to keep in the back of our minds.
I don't think technology, the problem is with case lines that technology at court is an additional barrier over and above any other technological challenges we might have. I'd like to go to Hasina. Hasina, let's hear your thoughts.
Thank you, Ronel and Ahmed and everyone else involved in putting this together. So I was, this morning still of the mind that Ahmed referred to, which is let's do a hybrid model, but clearly along certain lines where we have motions done virtually and trials done in person. Then I was having a discussion with one of my attorneys, and he actually said something quite important, but I'll come back to what he said in a second. The reason why I'm quite keen to have trials in person is because I have experienced significant difficulties with taking especially factual witnesses' evidence virtually. They're just not primed to be able to deal with the technology. I think expert witnesses, it's a little bit easier. And I think that, in fact, it probably compromised our case quite significantly in having to deal with a factual witness virtually. There were obviously the connectivity problems, but it's just, they couldn't even get the focus right. It was really, even though we had prepared them, I think it actually compromised our matter quite significantly. So I was of the view that, in fact, trials should be dealt with in person for that precise reason. And we have had hybrid trials, in fact, where we took factual witnesses in person, but we did expert witnesses virtually, mainly because a lot of the expert witnesses are senior people and would, in terms of their vulnerabilities, it would not have been advisable to take them to court. So that can also work. But then one of my attorneys today just said that, in fact, we should be flexible and we should let these matters be dealt with clear motivation and the judge making the final decision on whether it's going to be held virtually or in person. And I think maybe that's the most practical and pragmatic way of dealing with this, is that part of your practice note, you actually make a submission of why you want it virtually or why you want it in person. You can come to an agreement with your counterpart and you motivate for that. And then it's not as if anybody is forced by somebody else's preference. It's something that parties agree to with the judge. So that would be my final thought on that. Thank you.
Thank you for your contribution, Hasina. I'm going to give Vicky, let's see how things go with Vicky.
Hi, how are you?
Fine, and you, Vicky, let's hear you.
I think what we've all noticed is that it's not a clear-cut answer. I hear where HP is coming from, and I hear where everyone else is coming from, saying that we should go back to court. But it's not a simple look. When it comes to unopposed matters, I think we should stay virtual. There is no motivation why that shouldn't and should continue to be on a virtual platform. I mean, we currently have a problem now tomorrow, for example, in divorce court, where if it's left to the judges to decide, you have one judge who's now decided it's in person, and the other one that's virtual. And for practitioners, both lawyers and advocates, many times you're on different courts. So as Mohammed had said before, you're now forced to run to an empty court to now sit there with your phone to try and do a matter so that you can run back to an open court. I think if we decide to stay on a virtual or a physical court appearance, there needs to be very specific rules in place. Personally, I miss having to stand in a court. I miss the gravitas. I can see the breakdown in decorum with especially the younger practitioners, where if you sit face to face with a judge, it's easy to forget that this is a judge and not just your opponent. But on the other hand, I also remember just before lockdown, we were discussing putting women and practitioners into vans and going together to court because it had become that dangerous. So personally, as much as I miss going to court, getting that feeling, I do find that because I've been practicing a little bit longer, I'm better prepared to do it in person. I can't justify driving 40 minutes to town, risking my life, no facilities. Now I have to carry a laptop, so immediately I'm a prime suspect to be robbed, and then having to sit there for 3, 4, 5 hours. I can't do any other work, and then returning 40 minutes back to chambers. And as much as Cajee has said, what about moving it to Sandton? We've been asking that for years. That's never going to happen. So I think until there is a very real structure in place of how to deal with in-person court appearances, we should remain virtual, because it is not only the most safest option, it's the most convenient. And I say this lightly because I also find if you're busy with a trial, if you're busy with an opposed motion, and you're halfway through your arguments and a judge says to you, sorry, you broke up, I didn't hear you, you immediately lose your train of thought and the way you argue. But we can't just, it's not a simple answer of yes, let's go to court, no, let's not go to court. I agree that we need to maybe put stuff in place, be a little bit more flexible. But if we are flexible, give the practitioners, give the lawyers enough notice, because otherwise we have what we have now tomorrow, where a judge decides 3 days before he wants every divorced person, a plaintiff in person, and some can't actually appear. So what's the answer? He just removes matters of the roll. So you have a cost implication. If we can overcome those hurdles, then by all means, then maybe a hybrid system might be the best system. But since that's not in place at the moment, I think we should stay virtual for now. That's just my experience.
Excellent, Vicky. Thank you very much. I think what seems to become clear from the input we've had so far is that it's going to be very difficult, and if not short-sighted, to try and revert to the system exactly as it used to be. That I think would not serve the development, the virtual development over time.
Okay, I just want to come in here. I don't know how many of you guys follow Twitter. And I've been following Twitter, and specifically there's a guy called Ernst Roots from I think he's from AfriForum, and right now they've got a case going with EFF in the High Court. I think some defamation case, and he constantly puts in these videos that we're seeing now about his altercations with these guys outside court and inside court and things like that. I was just thinking now, if that trial was being run virtually, we wouldn't have all of that. But at the same time, there is that, a physical trial. Remember you interacting with colleagues. And I think he is on the platform. I did see his name. Advocate Soma said, the thing is, even like opposed motions, if you're sitting like in opposed motion with an opponent. Now, please, guys, I'm not necessarily expressing views one way or the other. I'm just trying to facilitate debates. You sitting in open court, whether it be a trial or in opposed motion, you got an opponent next to you. You can see how the argument is going. You can then facilitate discussions, and that physical contact can even lead to settlements more often than not. Whereas when it's being done virtually, I mean, you know, you're far distant from your opponent and from the judge, so it's not that easy to facilitate that. I mean, it's just something else we need to think about as far as this goes. Yes, and then of course, as I mentioned earlier, that our magistrates courts are still all in person. So you know, we're going to end up having two systems of justice, one for the High Court and then one for the Mag Court. But these are just things I'm just throwing out there. I'm not necessarily expressing views one way or the other.
That's why we're having this debate. Let's hear what Ria says. Ria?
Thank you, Ronel. I just want to touch on two things. One is we must remember if we like going back to court, it's not going to be going back to court the way we used to be used to it. You have your physical bundle in front of you and you go to court. We passed that already because everything is now on case lines. So people who's got this romantic idea that we're going to go back to the paper system like we used to, and it's going to be we passed that. We are past some of the things that we use, the way we used to do things in the past. It's a reality now that even if we go back to physical court, you will have to take your laptop with you because your matter is on case lines, and you will have to address the court from case lines, and you will have to direct the court on case lines. So this is the first reality that we will have to deal with. Then the second reality is, are we going backwards if we now say we don't want to be on a virtual platform anymore? Because like HP said, that's the future. So we must keep that in mind because we will all have to take our laptops to court. Are there facilities to accommodate us all? I mean, I can remember when we, like, for instance, went to court 1A. There's not enough space in those courts for counsel to each sit with their laptop to start preparing to present to the court. There was not even enough chairs in some of the courts. There is such a lot of physical equipment that's not there, that cannot accommodate us. In motion courts, and especially in motion court that is so busy. You can imagine if you have, like we used to do motion courts, one after the other. You will have to have your case lines ready when the one person sits down and got its order, that the next person is ready to present. And we have to keep that in mind. Then I just want to talk about the juniors. On each motion court role, there is a link. And any junior can go onto that link and can join court from the comfort of his home or his desk, wherever he is, or from his master's office, wherever he is. And he has the benefit to sit there and watch court and make notes, which you don't normally have when you are in physical court, because you don't have that facility to sit and make physical notes and listen in your own comfort to what a judge is saying back to the people. So to me, going on to virtual court for a junior, you can sit there in the comfort of your study, you can listen to the judge uninterrupted, nobody coming in, shuffling past you, stepping over you, interrupting you. You can have your notepad next to you, you can have your Erasmus next to you, you can look at what the judge referred people to. So from that perspective for the juniors, I think virtual court is actually better than sitting in physical court. When I was acting in divorce court, I asked Maria to facilitate that some of the pupils assist me with the underrepresented in court. And they were very happy to do that, and it worked very well. So there's no reason why that can still not continue in unopposed divorce court, so that the pupils still get their training and they still assist the court with the underrepresented. So there's not that many drawbacks for the juniors. I actually think virtual court can assist them.
Thank you, Ria. If I may add on to that, besides the very real issues of a very compromised infrastructure, the virtual platforms actually allow the juniors to attend a multiplicity of courts, to look and to learn. I know here at Virtual Chambers, we live stream the Constitutional Court, we live stream the Appeal Court. At the moment, there's some challenges with live streaming, but being able to sit and watch what happens, even if it's motion court, even if it's roll call. My pupil, I say to her, log into roll call so you can get the dynamics, see what's happening. Log into trials, log into the motion courts, and they can acquire a tremendous amount of experience and get to see how the more senior colleagues operate, which judges prefer what, how, what do they like, how should you approach it. It's extremely important. If we go back, and this is my view, and let me have one, if we go back to physical court, we take that away from the juniors. Let's hear Doris. Doris?
Doris?
Doris, your hand is up and you're muted and we can't see you.
Oh, okay, there I am. Thank you, Ronald. I'm sorry that I'm only joining so very late. And if this question has been answered, then I apologize for that. But in the court building, is there sufficient bandwidth for everyone to be on Wi-Fi while we are all using case lines in court?
I don't think so, Doris, to be honest with you.
So then how would we operate on case lines when we're in a courtroom?
Well, let me ask you, put it this way then, Doris. Let's say we didn't have a pandemic. What was going to happen then? How were we going to overcome
well,
that?
we would need Wi-Fi with or without a pandemic. We would need there to be Wi-Fi, because the alternative is for every advocate to use their own, to hotspot themselves from their phone. To be in court for 6 hours using data is an act of insolvency.
No, that's true. And perhaps I should also, perhaps on the other end, also say HP, I don't think they fixed the lift stop yet. Huh? So, I mean, you would have to be running up and downstairs. I think that would still be what's going to happen if we go back to normal. I mean, imagine having to go up, I think, 6 or 8 floors, 10 floors to where your trial is being held. But that's just, but that was there even before. The challenge was there even before.
Without broadband Wi-Fi and sufficiently broad bandwidth, it will be chaos, because even if there's Wi-Fi that's not adequate, then the little wheel on our screens will be turning and the case lines presentation will be a disaster. So I would say that that's the #1 requirement if there is to be such a system, and obviously Wi-Fi that doesn't keep on giving up the ghost. Thanks.
No, that's a good point.
Absolutely, Doris. Thank you very much. Yes. I see it's 10 to 4. Let's hear a few more contributions. I can see some of my colleagues there on the list of attendees. Let's hear you guys. Was it Vicky that had problems earlier with her Wi-Fi?
No, it wasn't me. Can I just say one thing? I'll keep it short. I mean, I love HB dearly. We've known each other for years. I don't always agree with him on the virtual stuff, but what I do agree is our profession has a habit of being stuck and reverting to old rules and going back to what we know. We know people in our profession who like change. Case lines was the first jump forward. We're not going back, and we shouldn't be going back. Even if we don't do a 100% virtual back to court type of platform, we need changes in our profession. We are lagging behind every other profession. So I do think, I think these discussions are good because we need different solutions. Going back to court, going back to the old ways is not the answer, in my opinion. Anyway.
Yeah, you loud and clear, Ricky. Good. Good. Ahmed, some closing thoughts on your part. Let's hear what you say.
Yeah, listen, guys. I mean, as I said, it's very interesting the views and that we are getting. HP, I think, has also, said that this is the future. We have been, thrust into the future much quicker than we expected. But going virtual seems as though that is the future. I mean, that's where we ultimately heading. I mean, so that is something very important to keep in mind. It is just also, but remember, guys, courts are also they're supposed to be open courts for everyone to be coming in unrepresented, etc. We also have those types of challenges. The physical state of our court, of course, is not ideal. We're both inside and outside. We are working on solutions as far as security, etc. goes. We have had 2 walkabouts with both late mayors recently, and we're hoping that we can carry on that initiative with the present administration. But and I'm not expressing political preference, but remember, every time there's a change in political leadership, it seems as though we're back to square one. We have to start all over again with a new group of people, and it also causes a lot of problems. And then one other challenge, remember, it's not only the court precinct itself, it's also the coming to and from court. Many of these acts of robbery, etc., even charges have fallen prey, happen some kilometers from the court building, in Braamfontein or some, one of the other exit routes from the CBD. So those are also things we have to keep in mind. But but then on the other hand, there is also this thing where people crave social interaction. Remember, we're social creatures at the end of the day. Also, we need to be in contact with our colleagues. We need to to talk to them, to learn from them, and that is also something we need to also just keep in the back of the mind. I don't know if there's ever really a substitute for physical interaction. We're not machines at the end of the day, where we can only communicate with each other through computers. Those are just some of my thoughts. I'm of course not being prescriptive at all, guys. I appreciate and I take we're going to take all views on board, and we're going to present them to the DJP when we see him next. But it's just that it's going to be, I didn't expect there to be such divergent views.
Yes.
On basically all aspects. I thought there was, as I said initially, there was consensus on trials. There appears to be no consensus on that either. So we're going to have to, I think, work out some sort of a solution and see how to return one to physical court for now, because I think that is the aim. Remember, there are bigger issues also at play here. So we're going to have to see how best that can be achieved, while at the same time maintaining all the benefits and advantages of the present system that we have evolved into.
Yes, thank you, Ahmed. Just before we close, I see Eric. We haven't heard from Eric before. Catherine, if you don't mind, Eric, a quick. You've got about a minute, Eric.
Thank you, Advocate. Mine is very short, and I just want to add a bit of a different perspective to the conversation. As a pupil this year, I think having to do everything online is very much efficient and cost efficient and saves time, because I can be at most places at the same time. After this meeting, I go to this meeting. After this, I go to this. And also having to attend courts without not having a car is a bit difficult. But if I'm at the comfort of my chair, then it is much more simple and efficient. So I think having to do not necessarily everything, but having to do most of the stuff online, it will assist us, those who can afford. Thank you so much.
Thank you, Eric. And that speaks, of course, immediately to the accessibility issue for especially our juniors, both from a logistical point of view, and getting to places and being at so many places. We speak to our pupils now, and that's why I'm happy we heard from Eric. Our pupils have the ability to then attend their lectures whilst they either just come out of urgent court, they'll attend the lectures, they'll consult with their mentors. A good point, Eric. Thank you very much. It's nice to hear from our pupils as well, and bring them with on the chat next week. We've got to keep our ears close to the ground, especially as far as our juniors are concerned. Hasina, don't fight with me. Let me just give Nick a chance quickly. We haven't heard from Nick.
Hello, colleagues. Can you hear me?
Yes, we can hear you clearly.
An excellent debate. I must say, I think that HB has seen the future. However, I do think we're going to get there in stages. So from my point of view, unopposed motions and matters like that should stay virtual, including opposed motions, and perhaps a few trials can stay in court. And I certainly know that last year I managed to get one of the judges on a certified commercial case to agree to hear us in court. And that was much better than hearing it online. And then the last thing, I'd just like to compliment the people on case lines. It's transforming our courts. It's magnificent. Thank you.
Absolutely, Nick. Thank you very much. Thank you very much. Guys, it's 4 minutes to go. Hasina, I'm going to give you a quick chance.
Yeah, I am going to be quick. Thanks, Renal. I just want you to say, Eric said something that just reminded me to mention something that we should possibly take into account carbon footprint when we take this decision. The thought of traveling, petrol, paper, all of that needs to be considered and factored into our decision making. Thank you.
Excellent angle. Thank you very much. Yes, that hasn't come up so far. All right then. I mean, thank you so much for bringing the committee to the people, if I can put it like that, for actually hearing us and giving us an opportunity to contribute to the work that you guys so selfishly do. It's much appreciated, and especially from the South African Bar Association. I'm sure that the recording, which is available on the website, will be viewed again. Thank you for your time. Thank you for SA Bar Association for creating this opportunity. And we look forward to next week's topic, and you must enjoy your evening. Thank you very much, AJ.
Just before we leave, guys, I mean, if there's any comments, I just put my email address in the chat. If you guys want to just send me those, especially those who hasn't had the chance to speak, or even those who did, I mean, you can just give me maybe drop me a message, so that we can collate these and put them in a proper format before the TJP when we meet with him.
Thank you, Ahmed. I'm just going to repeat that email address, and it gets straight to the horse's mouth. It's ACAJEE@chambers.co.za. And further written contributions, I'm sure will be much appreciated. Thank you, everybody.
Thank you.